Hello. As you probably know, one can ask questions here on the channel in the comments. And there was a recent question in continuation of our discussion about evidence and what evidence is weak and what evidence is not weak. The question was this one, or to make it easier to read, basically the question is, can someone or can I just say that I'm mentally ill as a defense for a fault? And I could probably expand this question to an option if somebody else could say, but he or she is mentally ill as a defense. So when the question is asked like that, like, can I or can somebody just say, the answer would be necessarily, yes, you can. That will be a testimony before a judge. So say, yes, you can. The real question would be how seriously the judge would take that statement, because appreciation of credibility of any evidence, actually, including the verbal evidence, the testimony, is the judge's prerogative. It's the judge's discretion. So the judge might listen to you and then decide that you were not trustworthy enough, you were not credible enough. So if you go before a judge, like stand up and in your own testimony, you say, but Mr. Justice, I'm mentally ill, therefore I cannot be at fault. Well, the judge might even believe that you honestly think so, but it's not enough for the judge to decide that you are not capable of exercising your civil rights. And if you did not bring any medical expertise, any social worker expertise with you, any specialist expert opinion, basically, then chances are that the judge will not take it as a credible statement. Sometimes those statements about like oneself are taken credibly, but usually when they constitute something which is called admission. It's up to discussion whether it's a good idea or not to take any statement that apparently goes against the person's interest as an admission and therefore as credible, because there might be reasons that we simply don't know about for a person to say something bad about him or herself. So if the statement, but I'm mentally ill, I am incapable, I am weak in spirit, if that statement would go against your interest, not as a defense, but against your interest, then it might be taken, to a certain extent, of course, as admission. But if you're bringing it in your own favor, so in your own defense, then such a statement probably will not go far. What if somebody else actually says about you that, well, he or she is mentally ill? Again, a person can testify, at least by the Civil Code of Quebec, about the first-hand knowledge. So what the person saw, what the person heard when he or she was present there. So there might be a testimony that you forgot this, this, and this, and you didn't recognize faces of your relatives when they came, and that you couldn't write, and you couldn't read, and you couldn't sleep, and you were babbling instead of saying something uh, like recognizable as speech or whatever. But whoever is making that testimony cannot bring a conclusion to that, an opinion to that. So if you bring those people to tell the judge that there were episodes where you behaved like a person with a weaker mental capacity, that might be interesting as a testimony for the judge. But if you bring somebody who would simply say, Mr. Justice, Madam Justice, this person is mentally ill, that would be an opinion, not a first-hand knowledge. And only experts, at least again by the Civil Code of Quebec, are allowed to bring their opinions. And their opinions are not binding on the judge. So the judge might listen and still disagree, even if that was an expert opinion, not to mention your neighbor's, friends, or relatives' opinion. So to summarize, can you or somebody else bring, as a matter of your defense, the statement, the allegation that you were or actually are mentally ill? Yes, you and they can. Uh, will the judge take it as a valid defense? Probably no. As a different question, I would say, but just to wrap it all up, what if you have a diagnosis? What if you have some kind of schizophrenia or bipolar or whatever? Does it mean that you're actually mentally incapable, mentally ill? Normally, no, because in that situation, again, only a judgment naming you, stating that you are legally incapable, would strip you of your civil rights. Otherwise, you will be a person with a diagnosis, but still capable of exercising your rights and therefore capable of carrying on responsibility for your actions. But if you bring a doctor, medical expert, who might conclude, based on, again, some documentation and diagnosis and whatever, that at the very point when you acted, your mental capacity was significantly diminished, so you basically didn't know what you were doing, then at least the intentional fault might be put in question. Again, we're not talking about criminal justice now. Criminal justice is a little bit different. We're talking about civil justice. So here, the court might even agree that you did not have this intention, but not every fault is intentional. And sometimes, even if you didn't really mean to cause any harm, but you actually did, it will be still your fault, and therefore there will be still responsibility. So just saying, probably not enough. Even just saying based on an actual diagnosis, most often is not enough either. And if you really wish to bring your weakness of mind, weakness of spirit before a judge as an argument in your defense, you'll have to take care of expert opinions, medical opinions, and particular conclusions with respect to your fault. Not exact conclusions, because, again, experts are not allowed to make conclusions for the court, but at least some suggestions about how your behavior could be explained because of that mental illness, and that the court, the judge, might take into account. But it's not that easy as just, can I simply say? Everybody can simply say. Not everybody will be believed by the judge. Thank you, and have a nice day.